But tonight, we start with what is a major order that has been passed in the Delhi riots case of 2020. Today, the Delhi High Court granted bail to Pinjra Tod activists Natasha Narwal, Devangana Kalita and a Jamia student Asif Iqbal Tanha. They are getting bail a year after they were charged under the UAPA Act. The court in its verdict pulled up the government for what they said was an attempt to stifle democracy. The court importantly said the right to protest in this country is not outlawed and does not amount to terrorism activity. It's a judgment that could have major implications for those who've been arrested for their role in the Anti-Citizenship Amendment Act protests in particular. It's our top story tonight.
In its anxiety to suppress dissent in the mind of the state, the line between the constitutionally guaranteed right to protest and terrorist activities seems to be getting somewhat blurred. The scathing words from the Delhi High Court as it granted bail to activist Natasha Narwal in a 2020 Delhi riots case. The court then followed with this ominous declaration. If this mindset gains traction, it would be a sad day for democracy. After over a year in jail, the Delhi High Court on Tuesday granted bail to Pinjra Tod activist Natasha Narwal, Devangana Kalita and Jamia student Asif Iqbal Tanha. They were arrested in May last year under the stringent UAPA law, charged with premeditated conspiracy in the Delhi riots.
You can't keep charging everybody under terror laws, which has very, very drastic consequences. So even the court's accountability increases in such cases.
In May, Natasha Narwal was granted brief bail to cremate her father, Mahavir Narwal, who had passed away from COVID-19 during the second wave. She had surrendered soon after. The arrest of the three has become a rallying point of civil society anger against the jail instead of bail impulse. Putting that precise impulse under its hammer, the Delhi High Court observed, "It is well settled that detention in custody pending completion of trial can cause great hardship to an accused, that it is improper for any court to refuse bail as a mark of disapproval of the past conduct or to refuse bail to a person yet to be convicted only to give him a taste of imprisonment as a lesson." Even more scathingly, in the Asif Iqbal Tanha judgment, the Delhi High Court observes, upon a closer scrutiny of the submissions made on behalf of the state, we find that the submissions are based upon inferences drawn by the prosecuting agency and not upon factual allegations.
Justice Mridul and Justice Bambani have actually said exactly what the law is, which we sometimes lose sight of.
Protest is not terrorism, and even a call for a chakka jam is not equivalent to terrorist activity. That is the gist of the judgment of the Delhi High Court granting bail to the three activists today. The court has also cautioned courts that just because the government has sanctioned prosecution under strict UAPA provisions does not mean that the courts must accept that blindly.
Finally, in a declaration of support for the arrested activists as well as student protesters in general, the High Court observed, "Having given our anxious consideration to this aspect of likelihood of threat and terror, we are of the view that the foundations of our nation stand on surer footing than to be likely to be shaken by a protest, however vicious, organized by a tribe of college students. Natasha Narwal has become the face of the state's crackdown on its perceived enemies. The implications of today's observations by the Delhi High Court could have far-reaching consequences." With Anisha Mathur and Nalini Sharma, Bureau Report, India Today.
My first guest today is a special one. I'm joined from Dibrugarh by Kalpana Kalita. Devangana's mother joins me. Appreciate your joining us, ma'am. I know this has been a difficult 1 year for you, and today must be a special day. After 13 months, your daughter is being finally released. Must be a feeling of great happiness, ma'am, above all else, or relief.
Definitely, it's a very, very happy day for us. After 1 year, Devangana got bail, and that too in UAPA case. that is very excellent happiness for us.
You know, how has the last 1 year been for you without your daughter by your side, with your daughter in jail, being denied bail repeatedly? How was the last year for you and your husband, who, when I went to Dibrugarh, I heard about how he was a top doctor working among people there. What has the last 1 year been for you and your husband and your family, ma'am?
Last year in 2020, on 23rd May, they were arrested, and for a few days we didn't have much link with the girls. They were taken to some police station, one police station to other police station. So initially we had difficulty to contact them. Through the lawyers only we were contacted, but later on, when video conferencing started, we had privilege to talk to her on video, and when we talk on video, we were really happy to see her on video. The whole family, we used to talk to her. That was good, and due to Devangana and Natasha only, it was possible that video call for 30 minutes in a week for each and every prisoners in the Tihar jail.
Video call, you said, ma'am, for 30 minutes every week was your connection with your daughter. Did you, though, give up hope? Did you feel disillusioned that here is a young woman who's being arrested and called her terrorist merely for her political views? Did you at any stage feel, has my daughter done something wrong which deserves a UAPA punishment?
Yeah, sometimes we had that feeling that, and we had faith on her that she hasn't done anything wrong. And she was arrested for protest, anti-CAA protest, but we had faith in Indian judiciary, though it is very slow and someone has to wait for a long to get justice. And when today morning we got the news of getting bail, Devangana and Natasha, we were very happy, and ultimately it's a victory of democracy in India today. The judgment.
The judgment is a victory for democracy in India. It is a victory in a way. It's a very strong judgment. It's not just your daughter, but Natasha also released, and Natasha has gone through a particular traumatic time. She lost her father, Mahabir Narwal, only last month. While she was in jail, she could only go for his cremation. It's been a traumatic time in a sense for both your families, hasn't it?
Yes, definitely. Definitely. He was a very close friend to us and we always miss him. Dr. Narwal was our strength. We get strength from him.
You got strength from him. What is the first thing, ma'am, you will do when you meet your daughter finally after 13 months as a mother?
We stay in Dibrugarh, so we will move to Delhi to meet her, let the COVID situation little stable. And definitely we are eagerly waiting to meet her, because since 1 year we have not met her physically, though we met her through virtual media.
As a mother, though, is there anything you will tell Devangana? Will you tell her, stop your activism, or will you tell her that, what will you tell her as a mother, ma'am?
We are proud of you. We are proud of Devangana. That's the first thing I will say to her.
So no regrets at all about all that has happened to your daughter and what she's gone through or what stance she has taken in her political activism?
No, not at all. Not at all. What they have been doing in the jail since 1 year, that is fantastic. They have been fighting for the jail reforms, even for the COVID vaccination, due to the Natasha and Devangana only and our lawyers. The COVID vaccination process has been finished yesterday, the latest news from the jail number 6. So we were happy, very happy and proud of our daughter. And we are proud of our lawyers also. Our lawyers, they fought very well, and since the beginning, after 23rd May they got arrested, they have been doing their best to get Devangana and Natasha free from jail. So we are proud of our lawyers also. And one more thing I want to say, that Devangana and Natasha
Go ahead.
are getting support and solidarity across the world also, and they have the access to the legal system. But there are some prisoners which are unable to access the support system and legal system, and they are languishing in jail for a long time. So it's a request as a mother of Devangana that the Indian judiciary should act little faster than now they are doing, and particularly for the underprivileged and who are languishing in jail in under UAPA. If they are not guilty, all should be released. I extend my solidarity to all those also.
You know, ma'am, listening to you, I know now where your daughter gets her strength from. I know also the circumstances in which what your family has gone through. When I came to Dibrugarh, I heard about it. I just want to say thank you very much for joining me here. Happiness and a happy day for you and your family. Thank you very much, Kalpana Kalita, for joining me here at the top of the news today. Let's raise those big questions then tonight that this High Court order has done. Does the High Court order of the Delhi High Court saying that the right to protest is not terrorism set a precedent? Will bail be the rule once again and jail an exception in such cases? Will the UAPA, the Unlawful Activities Prevention Act, be used much more sparingly? Some of the questions I'm going to raise. I'm joined in a moment by Justice Deepak Gupta, former Supreme Court judge, will join us. Indira Jaising, former Additional Solicitor General, who's taken up a number of UAPA cases, is already with us. Yashovardhan Azad, former IPS officer, with us. Dushyant Dave, senior lawyer, with us from the Supreme Court. Appreciate all of you joining us. Let me come to you, Indira Jaising, first, because you have taken up a number of these UAPA cases. And I want to understand from you, Unlawful Activities Prevention Act has resulted in a number of people not getting bail for years, sometimes without a trial. Will today's verdict make any difference in your view, Indira Jaising? You're on mute, ma'am. You're on mute.
Can you hear me now?
Yes, please.
Right. Rajdeep, I was holding up the UAPA Act for you. Can you see it here?
Yes,
okay.
I can.
So to answer your question, the UAPA Act has a very, very clear definition of what is terrorism. I have a big question to ask of the law enforcement agencies today. Do they read the UAPA Act? Do they understand the definition of terrorism? What the court has basically said today is that the UAPA Act is not attracted to the facts of the case relating to the three people who today have been granted bail. It's just not attracted. Why? Because what they did might amount to participating in a riot. And I'd like to say this loud and clear. My understanding of the law is every riot is an offense, but not every riot is a UAPA offense. This is what our law enforcement agencies failed to understand. And this is the message that the High Court has given out to the police and to those who lodge these FIRs. Before lodging an FIR, be careful under which sections of the law. One can understand an FIR of this kind in the facts of this case on rioting, on violence, but every act of violence is not an act of terrorism. This is what we need to understand. And it's regrettable that young people, college-going students, picked up, kept behind closed bars until we get this fantastic judgment by the High Court, which recognizes the difference between what is an act of violence and what is an act of terrorism. Of course, both are acts of violence, but one is an act of terrorism, another is not.
Okay, I think you make a very important point. The fact that they participated in a chakka jam, which many are now claiming, or the police are claiming, was part of a wider conspiracy that led to the riots, is not enough to prove terrorism. Justice Deepak Gupta, do you want to quickly respond? Because, you know, there was a judgment on the Sessions Court last year which clearly sort of denied them bail and said this is a wider conspiracy and therefore they deserve to be arrested under UAPA. Today, the High Court has gone to completely to the other extreme, saying the right to protest is not outlawed in this country, does not amount to terrorism. Two young women, or three people, a young student from Jamia, arrested and kept in jail for 13 months.
See, Rajdeep, I think the most important judgment is the Asif Tanha judgment. And according to me, that judgment is actually going to be a path-breaking judgment because it sets out all the various ambits of what is the UAPA and what is terrorism. As Indra Jaising said, every act, every crime is not a terrorist crime. You see, Justice Hidayatullah had put it very well in the Ramanor Loya case that you can take it, if you take concentric circles, the largest circle being law and order as one, then a central circle or the middle circle being public order, and the smaller circle being security of the state. So security of the state is those cases where actually the sovereignty of the country is threatened. And the High Court is very right in saying that just because a few college students decide to protest, our nation is strong enough to withdraw these protests, even if they're ill-founded or violent or not. No case of terrorism was made out. And because you must remember that in a UAPA case, the court can only grant bail if it comes to the conclusion that prima facie no case is made out. And the court, after analyzing the entire material placed before it, 19,000 pages in the charge sheet and the few hundred pages relevant to each one of the, and has come to the conclusion that, and another very important aspect is that the court has upheld the right to protest, the right to dissent. It says when we look at these cases, when we look at these crimes or these offenses, we must have to balance them with the right to protest. You know, it's very, very important.
It is very important. However, Dushyant Dave, there will be those who will argue that when the right to dissent, and I'm playing devil's advocate here, when the right to dissent leads to subsequent violence, can it be treated as a normal case of dissent against the state? This is the argument the police made in this case, saying this is a conspiracy, that it was their ideology, their belief system, their decision to go on the street that eventually resulted in the riots that took place in February 2020. And therefore, right to dissent per se may not amount to may not amount to an offense under UAPA, but when it leads to rioting, the police had claimed, then it comes under UAPA. It's a conspiracy. How do you respond, Mr. Dave?
Rajdeep, we must understand one thing. I mean, we have a judiciary. I'm part of that judiciary. We have a supposedly rule of law, but we have become a police state long ago. It's not just that the BJP government is abusing UAPA. Congress government equally abused POTA and arrested thousands of people who were clearly unwarranted arrests. You know, illegal arrest in this country is extraordinarily common. Thousands are languishing because of illegal arrest. And never is any action taken against a policeman for those arrests, or for a public prosecutor to oppose the release, or against the judges who refuse to grant bail or quash these false prosecutions against innocent citizens. In fact, many of these judges are rewarded with promotions to high courts and Supreme Court, I must say regretfully. Having said that, let me say one thing, that you know, I mean, only yesterday, the Prime Minister spoke at the G7 summit and said that we must all oppose authoritarianism and extremism. What is this? Is this country not facing authoritarianism? If Delhi police really wants to substantiate the charge of unlawful, activity or terrorism against these youngsters, I think the first thing that Delhi police should ask themselves, why is it they did not charge the BJP leaders like Piyush Goyal or Kapil Mishra and others who made the most seditious statements which led to violence
Anurag
and deaths.
Thakur, not Piyush Goyal. Let's be, Anurag Thakur had made a statement.
Piyush Goyal. Oh, sorry, even Piyush Goyal. I disagree with you, Mr. Rajdeep Sardesai. Anurag Thakur, Kapil Mishra and Piyush Goyal, all three made seditious statements, to my mind. And Delhi police, it's a disgrace to their uniform that it has singularly ignored it. I am also shocked that none of the judges in the course of these trials, in the course of these bail hearings, have even bothered to look at those statements and ask the police that if you are not taking action against these powerful people, why pick up these innocent citizens? So, it is a very serious, yes, today's judgment is a fantastic, I would say, it's a welcome judgment, but it reiterates the legal position which Supreme Court has settled for almost 75 years. But the difficulty is the same judiciary refuses to follow and picks up selectively these pronouncements of the Supreme Court to grant relief from time to time. So journalists get bail within no time in 24 hours in Supreme Court. Large number of people are being driven away by Supreme Court saying go to trial court and seek bail in completely bogus cases. So I think
you raise
judgment.
You raise a number of issues, Mr. Dave, which I will get even Justice Gupta to respond to. I await to know that exact statement that you claim Piyush Goyal made, which you believe is seditious. If you can show that to me, I'd appreciate it. But in the meantime, Yashovardhan Azad, can you respond to what Mr. Dave is saying, that the role of the police, you see, the police is now being accused of unlawful arrests in the case of Delhi riots or selective arrests, that you don't arrest the politicians who allegedly made these inflammatory speeches, but you arrest the students for their role in the participation of the anti-CAA protests. How do you see that? Is the police, and this is not just in the Delhi riots, we can go back to farmers being arrested when the Congress was in power in 1990s under Pota in Gujarat. The role of the police in implementing these anti-terror acts. Why should farmers be arrested in anti-terror or indeed student activists?
First of all, I agree with Mr. Dushyant Dubey completely that all regimes have misused these stringent acts. In this particular case, I also think that the Delhi police went overboard. We heard the legal luminaries just now talking about how the democratic dissent cannot be used to apply sections like the UAPA, and I totally agree with them. What they have stated is basically the truth, and let me tell you, that even the police officers know very well where these sections are to be applied and where, at least the conscientious ones. The issue is, where is the corrective mechanism? Is it being done by the junior officers to please the senior officers, or the senior officers are doing it to please the establishment? And mind you, there is a review committee which gives this sanction, and which was the basis of why the earlier court, the special court, gave. Are the police officers taking the cue from their political masters? I mean, are the police officers taking their cue from the political masters when they decide this case will be under UAPA and this case will not? No, that's exactly what I'm saying. This is the time for the police leadership to stand up and clearly say that we cannot go overboard on these issues, because you see, the sedition case, the NCRB report of 2019, the conviction in sedition case is 3%. There were 94 arrests and only 2 convicted. So it is quite clear that it is not going the right way. But a more important thing, which Dushyant Dubey said, was also about judicial reform. Why are the courts silent today if for 13 months, if these activists were in jail, and then the High Court says that even the prima facie evidence is not made out for the UAPA, then something is seriously wrong. The lordships will have to look into this as to what should be done. Should they take a suo motu cognizance? I mean, these are things which legal luminaries have to answer today.
Justice Gupta, you want to tell us that this selectivity that Mr. Dave is pointing out to, that even the police officer, Mr. Azad, is reluctantly accepting, but the fact is the selectivity begins with judgments. However, surely there should be consistency if someone is arrested for 13 months and now even a prima facie case is not made out under UAPA.
No, I totally agree with what has been said both by Mr. Dushyant Dave and Mr. Azad, that there has to be, you see, but the issue is, Rajdeep, you must realize that the powers that be have succeeded. Why do they say they have succeeded? Because they have quelled dissent for 13 months. There would have been hundreds of other young protesters like Asif, like Natasha, or like Devangana, who would have come to the streets to protest. But when you put them behind bars, put a law like UAPA against them, then they feel scared of coming to the streets and protest. Everybody doesn't have the guts which these 3 kids have shown. Now,
so I take that it may have a chilling effect. Sir, just a minute. So sorry to intervene. The police action may have a chilling effect, but why do judicial officers accept the police version so readily?
I wish they did not. I'm not saying that. I'm not supporting. I was just coming to this part. One is this, the police action. And I just wanted to say on the police action, in my view, as far as the Delhi riots are concerned, this police action is flowing not from some officers at this lower level, but it is flowing from the highest level. Everybody knows what is being done and what is not being done.
Right.
Coming to the courts also, we have judges and judges. Recently, you had some judges who had been passed very good judgments, even at the district judge level and the session judge level. But I would feel that the courts have been straying away from the principles of upholding the liberty of the citizens, and rather than being courts to protect the rights of the citizens, have become courts which sort of go on with the executive, which I hope it changes with this judgment.
Very, very interesting. Indira Jaising, you are arguing a number of UAPA cases. At least you argued these cases in the Bhima Koregaon case, where the likes of Sudha Bhardwaj are in jail now. It will be 3 years in August without even the trial starting. An eminent activist, lawyer, intellectual like her in jail. So I want to understand, will this have any impact on other UAPA cases in your view?
Yes, Rajdeep. And Stan Swami, by the way, about whom
And
you've
Stan
done
Swami,
a lot
yes,
of
a Catholic priest. Let this world know.
Yes.
Catholic priest who has spent his life working among the tribals, 84-year-old, arrested under UAPA, denied a straw sipper. But go ahead, ma'am.
Yes, Rajdeep. There is no doubt about the fact that this judgment will impact the hearing in the Bhima Koregaon case very positively. Because I've had a look at the documents, and the situation is identical. Even if you take what they're alleging against them to the hilt, there is no connection between the so-called alleged violence. First of all, there was no violence which followed the Elgar Parishad, and what they are now defining as terrorism, as an unlawful activity. Rajdeep, I'll tell you what the real problem is. You asked a question, are the police accountable to their political masters? You asked that question. Now, here's the answer. This government has made it a policy to use UAPA and sedition in every single case where there is even a whisper of violence, okay? And as I told you, violence and terrorism are not the same thing. Now, why does this happen? I want to tell you why it happens. Take this very case. What were they protesting against? CAA, the Citizenship Amendment Act. Now, the problem is this government conflates an objection to its policy to being an objection to the nation, okay? When I oppose the CAA, I do it because I disagree with it. It doesn't mean that I'm anti-national. Now, why are they invoking UAPA and sedition? Because they consider my objection to CAA to be anti-national. It is not. That is like saying, if you criticize the Prime Minister, you are anti-national. It's like saying the Prime Minister is India and India is the Prime Minister. It is this understanding which makes them invoke UAPA because they see it as an attack on the nation. They see it an attack on the sovereignty of the country. The law says very clearly it's only an attempt at asking people to secede from the territory of India, or an attack on sovereignty of India, or an attack on the defense of India, which is a terrorist act.
You make a very, very strong point that being anti-CAA,
a terrorist act.
Being anti-CAA is not anti-national, does not make you anti-Indian state. We need to recognize that. But Dushyant Dave, as you said, this is not the first time that governments have done this, misusing anti-terror laws. What's the solution? Is the solution, in a way, diluting some of these laws? What is the solution? Give me a legal solution that you have, Dushyant Dave.
Well, the solution is in strengthening the criminal administration of justice. So beginning with the police, the public prosecutors, the law officers of the government of India at the highest level, the Attorney General and the Solicitor General and additional Solicitor Generals. And of course, the judges from the lowest ranks to the Supreme Court. Everyone needs to be sensitized to the constitutional values and constitutional morality. Unless and until we decide that we will not take away any citizen's basic human rights or fundamental rights without there being strong justification for arrest, it is not going to help us. At every stage, everybody has to be mindful of that. a police constable to a police superintendent or police DIG or DGP or the public prosecutor or the judge. As soon as anybody is produced before the judge has to ask. When these kids were produced before the judge for the first time in 2020, on that day, judge should have thrown out the prosecution case and said, what is this nonsense you're talking about? But the judge didn't. And the problem is that even while granting this bail today, the High Court has not indicted the judge who refused to grant the bail. The High Court should have criticized the judge and said that, is this your knowledge of law? I mean, is this how you respect the citizens' rights? This judge has no business to be in judiciary. If he, rejects bail applications of some youngsters merely because they were protesting, does he not know that Supreme Court has said for a number of years that right to protest is a fundamental right? Now, what do you do with this kind of a system? You have to overhaul it. It has to begin from the bottom to the top. The difficulty is nobody is willing to do it. I mean, there are pockets of isolation where there is excellence, like today's two judges are outstanding judges. They have always been standing up for the citizens. But how many of them are there? I mean, in Delhi High Court, Harsh Mandar had filed a petition which came up before Chief Justice Patel's bench, where he wanted prosecution to be launched against these BJP leaders for their provocative statements. And the Chief Justice didn't agree and forced him to withdraw, saying you go somewhere else. Now, is this the kind of an approach that the High Court should have? I mean, I am really seriously worried that we are actually have become a police state where nobody is safe except the rich and the powerful. None of us are safe. Any one of us can be picked up on completely frivolous grounds. We can spend a long time in jail and nobody will bother about it. How are you going to compensate these three young people for having spent 1 year? Do we want to radicalize them? Do we want to create a situation where instead of fighting terrorists, we are fighting citizens and converting them to terrorism? I mean, that's precisely what's happening.
Very, very strong words, and that exactly is where I want to end this by asking Yashovardhan Azad, who will give these girls back 13 months? There are a number of people who've been arrested over the years under UAPA, under POTA, as I said in a previous, under TADA and earlier regimes, and they are clearly not guilty of terrorism. Who will give them? Will the police apologize? Will anyone apologize to them today and say sorry at least?
In fact, I had raised this first during my speech, and quick 3 points. First, the judicial reform about which Mr. Dushyant Dave has been bold enough and graphically described, which I couldn't have done in any case because I'm scared of loud ships. Second is the drastic reform in prosecution. This prosecution is not only third-rate, it is abysmal all over, and they are just not interested in prosecuting cases, but something else. And the third, last, is that make police investigation accountable to the court and not to the political executive, which should only hold the law and order reins. And that will give you improvement. But as Mr. Dave said, that nobody wants to bell the cat.
No one wants to bell the cat. And the important question that I want to raise, who will compensate these young activists for 13 months that they've spent for a case that has not even been prima facie built that they are terrorists? The words of Devangana's mothers should echo in our hearts, as well as the lawyers, judges and police officers who've joined us here today. Thank you all very much for joining me here on the news today. Hopefully, this judgment will have a salutary impact on our judicial system. Let's take a break. When we return, we're turning back to COVID. The government confirms the first death linked to anti-CAA